So we'll start with some introductions. Hi, everyone. My name is Sarah Chronister. I'm an attorney in the housing unit of Bay Area Legal Aid in our Santa Clara County Regional Office. And then I'll let my colleague Kevin introduce himself.
Hi, everyone. My name is Kevin Lee, and I'm a staff attorney of Bay Area Legal Aid, colleague of Sarah Chronister. Thank you.
So today, we will cover quite a few topics. Again, like Nicole mentioned, this is a three-part training. So today we are going to focus on tenants' rights. So this is rental qualification, understanding leases, habitability issues that might come up as a tenant or in the eviction process, some criminal history background information, best practices for tenants and landlords, a little bit of an overview of the Tenant Protection Act. This was AB 1482. And then we will end on an overview of the Violence Against Women's Act, or Vawa. Next Monday, we will do a fair housing presentation, which will go over federal and state fair housing laws. And then on October 7th, we will end with an eviction process overview. So this will be kind of going over the court process of an eviction. So it's a lot of information. We understand this is not topics that everyone is maybe very familiar with. So again, like Nicole mentioned, if you have questions, feel free to ask them throughout the training, but we do have a designated chunk of time at the end to go over questions. And then anything that we didn't get to, we can follow up next week with answering some questions, or just through email if we don't get to your questions. So please do ask along the way if you have things that come up. So again, this is today's agenda, going over the tenants' rights. And then I will start by giving some background about Bay Area Legal Aid. I'm not sure how familiar you guys are with our organization. And so in general, we're in all 7 counties in the Bay Area, and we cover quite a few different practice areas. So we serve low-income residents in the Bay Area counties. So we cover Alameda, Contra Costa, Marin, Napa, San Francisco, San Mateo, and then Kevin and I are in the Santa Clara office. And so I'll briefly go over our 8 practice areas. These are not all just in our Santa Clara office, some are regional. So the first practice area we have here is our housing unit. This is the Housing Preservation and Homelessness Prevention Unit. This is a mainly eviction defense, but also in general, lots of different landlord-tenant matters, fair housing issues, subsidized housing issues, pretty much anything having to do with landlord and tenant. Then we have our immigration practice. This provides services to immigrant survivors of domestic violence. The services include Vawa self-petitions, which we'll talk about actually a little bit at the end of this presentation, help with U visa petitions, temporary restraining orders, and other services for survivors. They work closely with our domestic violence prevention practice. This is the next thing on the list here, which helps with getting restraining orders and other domestic violence issues with our family law team. We also have a health consumer center. This is one of the regional practices. So this assists clients with navigating services from public and private health insurances. This would be Medi-Cal, Medicare, in-home supportive services, and other county health programs. So that unit is really helpful. I know that's an area that a lot of people do not have a big expertise in. So we'll share some contact information in a slide or two. Then, like I mentioned, we have the domestic violence and sexual assault prevention team. This is our family law team. They help with obtaining temporary restraining orders, divorces, child and spousal support orders, and custody and visitation orders. We also have an economic justice unit. So they help with public benefits programs, SSI, SSDI, general assistance, food stamps, CalWorks, anything that has to do with those public safety net programs. We also have a consumer law team. This deals with issues relating to the Fair Credit Reporting Act, fair debt collection practices, bankruptcy counseling, and more. And then finally, we have a youth justice practice. This assists with areas including foster care, health access for youth, SSI, education, housing, and homeless youth services. So a little bit about eligibility for Bay Area legal aid. Again, the clients need to live in one of our 7 counties. They also need to be either US citizens or be eligible immigrants. And eligible immigrants include people who have an application for permanent residency pending, are permanent residents, refugees, or asylees, or any immigrant who is a victim of domestic violence, sexual assault, human trafficking, or other violent crime. For the income requirement, generally a client's income needs to be under 200% of the federal poverty line. There are some exceptions in each one of our units for different grants. And so if you're unsure whether or not you or a client might qualify, please call our legal advice line or our health consumer center, and they can check your availability or your eligibility. And then I will let Kevin take it away. And these are the numbers to contact our services. And again, these slides will be shared.
Hi, everyone. Good morning. So let's get started with first topic for today, which is tenants' rights. So generally, landlords require certain rental qualifications before renting a unit to a tenant. I'm sure everyone has gone through this process. I mean, like each landlord is different. There will be different qualifications depending on who the landlord is. Some landlords are very lenient, while some are more strict. So it depends. Landlords generally request names of employers, previous landlords, and references. Landlords may also request applicants pay a fee so that a landlord can obtain a credit report. Beginning in 1998, the fee was limited to $30 and can be adjusted according to changes in the Consumer Price Index. And currently, the limit is around $50. So yes, $50. And landlords may choose to not accept a tenant depending on their credit score or if they have an eviction on their record. If a tenant's credit score may not be great, they can demonstrate proof of their ability to pay rent based on past rent payments or proof of income. And landlord is not obligated to accept this alternate evidence, but it can be persuasive.
Okay, so a little bit of background on criminal history as it has to do with background checks or tenants applying for housing. So this is relatively new regulations that came out in January of 2020, which say that, so these regulations were interpreting anti-discrimination laws. And this actually prohibits landlords from considering certain types of criminal histories when they're doing background checks for tenants or just a tenant application. And so the things they can't consider are arrests that did not lead to a conviction, participation in a pretrial or post-trial diversion program, any record of a conviction that has been sealed by the court or possibly expunged, or any conviction coming from the juvenile justice system. So it's a little bit more nuanced, but just kind of as a summary of somewhat complicated law and regulation, these are the things that a landlord can't consider when they're determining whether or not a tenant meets their qualifications to become a tenant. The regulations also prohibit landlords from having these blanket bans on their applications. So for example, sometimes we'll see ads or Craigslist ads that say no felonies. And so that seems like maybe that's a legitimate thing to include on a rental application, but actually with this new regulation, that is illegal and would be discriminatory. So no blanket bans on all kinds of convictions. And so a landlord still can consider some criminal histories, but it has to be individualized. So they have to take each applicant's potential criminal history and then determine if whatever conviction they might have, if that specific conviction actually stops a tenant from being a good tenant. So it's a lot more case by case now than it was with prior regulations. Oh, goodness, sorry. Okay, a little bit more in detail about what a housing provider cannot do. So they can't access criminal or civil records older than 7 years. So if this comes up on a background check and the conviction or criminal record is older than 7 years, a landlord cannot use that as part of their determination for an applicant. They also can't ask for or use information about arrests that did not lead to a conviction. Again, no blanket bans on like no felonies or something that's excluding all individuals with criminal records. So an ad saying no one apply that has a criminal record. Again, a little bit from what we talked about on the last slide, they can't ask or use information from the juvenile justice system or convictions that might have been expunged or sealed. They also can't deny someone who might have a conviction or a criminal record stemming from a disability if that tenant then requested some kind of reasonable accommodation. So these are terms that maybe are not familiar to you guys, and it is what we'll be going over next week. So you'll get a little bit more in depth into how a tenant or an applicant might request a reasonable accommodation. And then finally, a landlord can't deny someone with a conviction or a criminal record relating to domestic violence. So this has to do with the Violence Against Women's Act, which we'll cover at the end of today. So if there is any federal subsidized housing or other potentially discriminating unfair housing laws at issue, that applicant might have some protections. Just as kind of an example, because I know this is kind of in the abstract, it might be a little bit confusing. There was a recent case where a person was, they had a conviction and then later got into an accident and then became paralyzed. And so then they needed a live-in aid. A landlord denied that tenant due to that criminal history through a tenant screening program, but they didn't take into the fact that the tenant's disabilities, being completely paralyzed, actually prevented him from being a threat to other tenants because he was now paralyzed. So in that case, that tenant, if requesting a reasonable accommodation, a landlord actually would potentially need to not consider that criminal history because it's not stopping the tenant from either being a good tenant or it's stopping that tenant from posing a threat to other tenants at the units. So housing providers that do a background check or obtain other consumer reports or criminal histories from a third party are subject to the Fair Credit Reporting Act. And because of that, they have to notify an applicant if they take adverse action based on what they find in that background check. So if a landlord does a background check, it comes up with multiple convictions or criminal histories that the landlord then uses to not approve the tenant, they have a duty to notify that potential tenant of that adverse action. Obviously, this does not happen consistently. There's a lot of reasons why a landlord might reject a tenant, and it's kind of on the landlord to offer up this information. But under the law, they are supposed to notify the tenant if this was even a part of why their application was denied. Okay, we'll start with a couple hypos. Let me see if I can share a poll, and if I can, I'll have you guys all respond to the poll, and then we will give kind of a brief answer. So let me see. Okay, hopefully that launched. So I'll read the question. So a landlord posts an advertisement for an available one-bedroom unit. The advertisement specifically states no individuals with criminal records. Is this permissible? Yes or no? give it another minute. We've got about 30 of you left to answer, but I see quite a bit of consensus in our answers. So, as most of you stated, the answer would be no. So this would be an impermissible statement because, again, that blanket ban that the new California regulations don't permit. Okay, and Kevin, I think I accidentally stole your hypo there. So if you'd like to do number 2, I'll see if I can share the next poll.
All right, could you share the next question? All right, a landlord posts an advertisement for an available 1-bedroom unit. The advertisement specifically states no individuals with prior felonies. This is permissible.
Give it another minute. We've got about 60% of you answering so far. Okay.
I guess, all right, so like it's another example of a blanket ban. So this is prohibited under California law. Thank you all for answering, and let's proceed to the next slide, please.
And so I'll just note that quite a somewhat significant number of you still said yes. And so it can be a little tricky because as a landlord, you might be thinking, well, I do want to stop people with potentially prior felonies from applying or from becoming tenants. But again, with this new California regulation, these blanket bans are prohibited. So it's something to be on a lookout for if you have clients who are looking for apartments, or if you have maybe clients or yourself, if you're being denied housing and you're not sure if it's because of that criminal history, or if you see these blanket bans.
All right, so on habitability, so a landlord has a legal duty to provide a habitable unit. And what does habitability mean? So it means that the rental unit is fit for occupation by human beings, and that it substantially complies with state and local building and health codes that materially affects tenants' health and safety. And the Civil Code and the Health and Safety Code outline specific features of a habitable unit. And here's some examples of what makes a unit habitable. So effective waterproofing and weather protection of roof and exterior walls, including unbroken windows and doors. So for example, yesterday it rained. So like the roof must block all the rain from coming into the premises. So these kind of things. So plumbing facilities in good working order, hot and cold running water connected to a sewage disposal system, gas facilities working, heating facilities, electrical system, clean and sanitary, adequate trash receptacles, floors, stairways, and railings. So for example, I recently had a client whose hot water was not provided at all, and it was deemed uninhabitable. So in this kind of instances, you could actually, and the landlord agreed to deduct rent based on the fact that he was not able to provide hot water. So it's like hot and cold water can also make up what habitability means. And in addition to the above requirements, each rental unit must also have all of the following: a working toilet, wash basin, bathtub or shower, kitchen with sink, natural lighting in every room, safe fire, and all the other stuff. So a landlord must provide these habitable conditions in a unit, or he's breaching his duty to provide habitable unit. Next slide, please. So what should a tenant do if repairs are needed or the unit becomes uninhabitable? Tenants should give notice to their landlords immediately. I know that it can be uncomfortable to contact the landlord, and it's not always a pleasant experience, but you must notice notify the landlord immediately. And it is best for the notice to be in writing and for the tenant to keep a copy for their records. And what if a tenant substantially causes an unlivable condition? Then a tenant may be responsible for the cost of the repairs. A tenant may also be responsible if they substantially interfere with the landlord's ability to conduct repairs. And tenants' remedies if landlord does not conduct the repairs, contact the code enforcement immediately. If repairs are required and the landlord does not conduct repairs when given reasonable time after a notice of the repairs that are needed, a tenant can contact code enforcement. Code enforcement is a government agency that can conduct investigations and mandate that the landlord complete the repairs. However, it also follows a risk. If the habitability issues are severe, code enforcement red tags the property and require the unit to be evacuated. This would place the tenant in a situation where they have to look for an alternative housing. So best to advise tenants of this risk before contacting the code enforcement. On the other hand, a landlord may be responsible for providing relocation assistance to the tenant. However, in practice, a tenant sometimes may have to start legal proceedings to recoup any relocation, depending on the landlord. Another option they could use is repair and deduct, but it's not recommended. So this remedy allows a tenant to deduct the money from the rent to pay for repairs of defects in the unit if the repairs would not cost more than 1 month's rent. This remedy covers substandard conditions that affect the tenant's health and safety, and that substantially breach the implied warranty of habitability. A tenant may not use the repair and deduct remedy more than twice in any 12-month period. The tenant or household or guests or pets must not have caused the defects that require the repair. The tenant must first inform the landlord, preferably in writing, of the repairs that are needed. And the tenant must give a reasonable period of time. And the reasonable depends on the repair needed, but generally 30 days, unless, for example, heater is broken in the winter, then a couple of days may be considered reasonable. The landlord does not conduct the repairs in the reasonable period of time, then it's not good. So the risks, the defects may not be serious enough to justify using the repair deduct remedy. Landlord can file an eviction based on non-payment of rent, and the tenant may be evicted. Because of the risk of eviction, it is very important that tenants who use this remedy document the defects and notice given to the landlord because of the risk of eviction and the steps required to be afforded this protection. So therefore, this remedy is not advisable due to the risk of eviction. There's also the abandonment option. So instead of using the repair and deduct remedy, a tenant can abandon the unit. Similar to a repair and deduct, the defects must be serious and directly related to the tenant's health and safety. The tenant or household, guest or pest must not have caused the defect, and tenant must inform the landlord, preferably in writing, of the repairs needed, and give the landlord a reasonable amount of time to complete the repairs. If the repairs are not completed, the tenant may abandon the unit and will not be responsible for the rent per their lease agreement. There's also risk. The defects may not affect the tenant's health and safety seriously enough to justify using this remedy. The landlord may sue the tenant to collect additional rent or damages. Because of this risk, tenants should document the defect along with the notice provided by the landlord. Another option they can exercise is withholding rent. But again, it's not recommended. Tenant can withhold some or all of the rent if the landlord does not fix serious defects that violate the implied warranty of habitability. The defects must be substantial and they must be serious ones that threaten the tenant's health or safety. The basic requirements for this remedy include the defects must threaten health and safety of the tenants and be serious to render the unit uninhabitable, the tenant or household must not have caused the defects. The tenant must inform the landlord, preferably in writing. The tenant must give reasonable time to make the repairs. If the landlord does not make the repairs, the tenant can withhold some of the rent. Tenants should save the withheld money and not spend it. The tenant may have to pay the landlord some or all of the withheld rent. So then what are the risks? The defects may not be serious enough to threaten the health and safety. And if they withhold rent, the landlord may give the tenant an eviction notice and initiate the eviction process. So next slide, please.
Kevin, there is a question. What if the hot water works sporadically? So it keeps breaking down after the system is repaired. It's a 6-story building, 102 units. And when it is working, it alternates between hot and cold during showers.
So I can answer this. So at any point, you should have hot water. So heat, hot water, all of the things that Kevin listed as being necessary for a habitable unit. So even if it's getting fixed, but then breaking again, you still have a habitability problem. So unfortunately, like Kevin just listed out, all of these potential remedies come with some risks. And so what a tenant should do in that situation, or if it's you that's in that situation, is continue to notify your landlord immediately in writing of the problem. Keep your own written record of the times that you contacted the landlord each time that that hot water went out. And it is still the landlord's responsibility to continue fixing that problem. And if it's becoming so, if it's, you know, if it's been 10 times that he's been trying to fix it and it keeps breaking, this might be a bigger problem. And so then you can go through the steps that Kevin listed here, where it might be that you need to be moved to a different unit or potentially break your lease, abandon that lease, because the landlord can't fix the problem. And so even though they're fixing it, it's coming back, you still have a habitability problem if it's not reliable enough. You have a right to hot water, adequate heating. And then depending on the severity of the problem, again, if it's the depths of winter and it's freezing, obviously that repair needs to happen a lot quicker. Hot water would be something that I also think, obviously, a landlord can't wait 30 days to fix. I think that answers that question. If there's any follow-up needed, just let me know.
And there's another question. If a client is experiencing, like their unit has an asbestos condition, so the kitchen and the bedroom need to be vacant for that abatement, the client's expected to move all of their personal items and belongings into the only other room that's available, which is a small living room. So they're asking whether property would need to provide other means for the client's property to be stored to allow for the abatement project to be completed.
So it kind of depends. It's hard to give a just blanket answer to that. It might depend on if the kind of underlying problem was a problem with the building, which then it's the landlord's responsibility to fix. And then the landlord might be on the hook for some either relocation fees, like maybe a couple nights in a hotel, or potentially maybe a storage unit or somewhere for that tenant to keep their belongings while the repair is happening. The problem here is that if the landlord is refusing and then the tenant either doesn't move their things or doesn't have a place to move their things, they might have some civil remedies. They might be able to later sue the landlord because of that lack of use. But in the meantime, a landlord could say, you didn't move your property, and so I'm going to serve you with an eviction notice. And so it's hard to answer that question, because ideally that tenant would have protections. It would be the landlord's responsibility to, you know, provide them a place to sleep if the repairs mean they can't have access to their unit. But in reality, that situation should look like a conversation with the landlord and possibly a reasonable accommodation request on behalf of the tenant. And so if that tenant maybe has some disabilities, they maybe are elderly, they can't move their belongings into one room, maybe they have medical equipment that can't all fit into one room, this might look like a reasonable accommodation request to the landlord asking to be placed into a hotel for however many nights, or potentially another vacant unit in the building. And then also maybe like scheduling that repair, working around the tenant's schedule. Again, if there's issues with potential disabilities for the tenants. So again, hard to answer just a strict yes or no, but it does sound like potentially some reasonable accommodation requests, and it ultimately should be the landlord's responsibility to ensure the tenant still has a habitable place to live through that duration of their lease.
Wonderful, thank you. I think that is all the questions that have been asked so far.
Okay, great. And then just right before I go to the next slide, just the last bullet point there, the kind of final remedy for the tenant would be that if the landlord is breaching and their rights under the lease, if there's habitability problems, a tenant could file a lawsuit based on that warranty of habitability breach, or potentially constructive eviction. If the premises is so bad that the tenant has to move, that is deemed a constructive eviction, meaning the landlord didn't go through the eviction process, but the tenant still had to leave because the unit was in such bad shape.
Well, thank you, Sarah, so much for answering those questions on my behalf. And all right, so now let's talk about the best practices. Duty of good faith and fair dealing. So for example, a landlord may not fail to make repairs simply because a tenant has paid rent late in the past. Additionally, tenant cannot pay rent late on purpose simply because they did not like the way a landlord may have handled a certain situation. And very important for tenants to document what the unit looked like before moving in. And when they moved out, take a picture always. Landlords will do close inspections of the unit to determine how much of the security deposit they should retain to fix any issues that were beyond normal wear and tear. For tenants to ensure they receive the security deposit, they should clean the unit to how it was when they moved in and make sure they document what the unit looks like. If a tenant leaves the unit with trash and debris everywhere, or with broken items that they did not inform the landlords about, then they likely will not receive their entire security deposit back. Always communicate with the landlord of the problems in the unit. Landlords and tenants are both expected to communicate with each other on relevant issues, so like the repairs, rents, general requests. All communication should be in writing. If you communicate with landlord orally, be sure to send a follow-up email or a letter summarizing your conversation. I've still, like in practice, I've seen multiple cases where an agreement was made orally, but then our client, the tenant, was unable to prove that oral agreement actually existed between the landlord and them. So it's always best practice to communicate to the landlord, maybe via text, emails, like something that can actually have a tangible evidence later, rather than orally. So also always pay rent on time, like the common sense requires. Next slide, please.
Sure, and just to follow up on the putting things in writing. So it's not that oral agreements with your landlord don't have legal authority, they do, but in practicality, if it's not put into writing, if it's not a follow-up text or a follow-up email or a follow-up letter, if you go and try and prove the existence of that agreement, it's going to be the landlord's word against yours or against the tenant's, and that's just more difficult. So it's okay to have an oral agreement with your landlord, but again, best practice, put it in writing so there is some kind of documentation that that agreement happened. So we will do another hypo. I will share a poll. I actually don't see this one on a poll, so I will read this one out. And then if you want to put your answers in the chat, and maybe we'll wait for a number of you to answer, and then we'll go over the responses. So for this hypo, Tammy tenant has a rental agreement where she agrees to pay $1,000 in rent. A year into her tenancy, she has a roach infestation in her unit. She verbally tells her landlord, and the landlord immediately contacts pest control. Pest control comes in and eradicates the roaches. And then 6 months later, Tammy notices roaches and ants again in her kitchen. She does not tell her landlord and withholds rent for the month. What best practices should Tammy, oh, there it is. Thank you for sharing the correct poll. What best practices should Tammy have done? So A, provide notice in writing. B, inform the landlord about habitability issues starting again. C, taken pictures. And then D, all of the above. And then I see some of you are answering the second question there already. So true or false, if Tammy's landlord files the eviction, Tammy should be able to assert the habitability defense still. Wait another minute. Okay, we've got a majority of you answering, so I will end the poll. So pretty much all of you got this first one right. So all of the above, these are all things that Tammy should do in this situation. So not that A and B were wrong, but best practices, do all of these things. Talk to your landlord, put it in writing, take pictures, do everything that you can think of to document it. And then for the second question, this one was a little bit trickier, and we can see from the results that you guys were a little bit more split. So the answer still here would be true. So even though Tammy didn't notify her landlord the second time around with habitability problems, that's still a defense that she can bring at an eviction lawsuit. The problem is if she hasn't notified her landlord the second time around, it might not be as it might not be as good of a defense because the landlord can say, well, I didn't know about the habitability problems the second time around. But it is still something that the tenant can bring as a defense.
All right, so next we're going to be discussing another very important topic, which is the Violence Against Women Act, also known as Vawa, and the protections this act offers as it relates to housing. Next slide, please. So public housing agencies and landlords or managers of covered federally assisted housing have special duties under federal law when renting to tenants who are domestic violence survivors. VAWA is intended to encourage survivors who are receiving housing subsidies to report and seek help for the abuse against them without being afraid of getting evicted. Also, VAWA protects individuals from being discriminated against because of acts of domestic violence, sexual assault, dating violence, and stalking committed against them. It applies to survivors regardless of sex, gender, identity, or sexual orientation. However, again, VAWA does not apply to private housing and only applies to federal housing programs, such as, next slide, please. So here's the list of these federally covered and state covered housings. So VAWA covers various federally subsidized housing programs through HUD, the Department of Agriculture, and the Treasury Department. The slide lists the programs that are covered under VAWA. For example, public housing, Section 8 vouchers, project-based Section 8, and low-income housing tax credit units are all programs that are covered under VAWA. Next slide, please. VAWA covers persons who are subject to the following. First, domestic violence, which is any felony or misdemeanor crimes of violence committed by a current or former spouse or intimate partner, person with whom the victim shares a child, person who is or has cohabitated with the victim, a person against whom a victim protected from acts under state or local domestic and family violence laws. The term spouse or intimate partner of the victim includes a person who is or has been in a social relationship of a romantic or intimate nature with the victim as determined by the length of the relationship, the type of the relationship, and the frequency of interaction between the persons involved in the relationship. Now, the second category, dating violence, which is violence committed by a person who is or was in a social relationship of intimate nature with victim. There are three factors to consider to determine the nature of the relationship. First, the length of the relationship. Second, the type of relationship. And third, the frequency of interaction between the persons involved in the relationship. The third category is sexual assault. Any non-consensual sexual act prohibited by law. Fourth category is stalking. Any conduct directed toward a specific person that would cause a reasonable person to fear for safety or suffer substantial distress. Vawa applies to both applicants and tenants. And tenant here means household members on the lease. This does not include guests or unreported household members. It also applies to tenant in mixed status immigrant families.
So the Violence Against Women's Act, VAWA, protects survivors potentially from eviction. So generally, a person can't be denied housing or assistance with housing based solely on criminal activity that is the basis of or as a direct result of their status as a domestic violence survivor. So this includes adverse factors resulting from the abuse, for example, criminal history background checks, or an eviction being filed against that tenant. So an incident of domestic violence is not, under a lease, a serious or repeated lease violation or good cause to evict a survivor. So if you have a tenant who is getting a 3-day notice or has an eviction filed against them because of something that stemmed from domestic violence, dating violence, any of the things that Kevin talked about at the last slide, the tenant potentially has some eviction protections. There, like always, is an exception to this. So housing providers can still evict or terminate assistance due to an actual or imminent threat to other tenants or to their employees if their survivor is not evicted. And so this is a situation where you have a tenant who is receiving an eviction notice from their landlord due to a domestic violence incident. It might still be possible for that landlord to move forward with the eviction if they can show that there was an imminent threat to the other tenants if that party is not evicted. And this isn't kind of an abstract concept. A landlord actually has to show that there is an actual and imminent threat of physical danger that's real and that would actually occur in an immediate time frame and could result in the death or serious bodily harm to other tenants or employees. So it's a pretty high bar. When determining whether or not there is that imminent threat, there's some factors that a landlord needs to consider. So they have to look at the duration of the risk, the nature and severity of the potential harm, the likelihood that that harm might occur, and then the length of time before that harm might occur. So if we're in a situation where maybe the abuser is incarcerated, or we know they're out of state, or for some reason we kind of know that that harm might not be imminent, a landlord can't use this exception to still try and evict the survivor. So an eviction should be the last resort for a housing provider. They can instead potentially transfer that survivor to another unit. They can also potentially involve the police on behalf of the survivor or seek other legal remedies like maybe a restraining order to try and keep that abuser off the premises. So again, the eviction should be that last step. If a landlord is jumping straight to evicting the survivor, they are potentially violating these eviction protections under VAWA.
There are a couple of questions in the chat. So do these eviction protections remain if there is damage to the unit due to the domestic violence? And then are unit repairs due to DV incidents covered?
So this is specifically talking about eviction protection. So this is if an eviction is being filed against the survivor, they can raise the affirmative defense of Vawa and be protected against the eviction. So it's a little bit separate than if there's damages in the unit, or if what was the second question? So if there was damages.
Well, I'm assuming the first question was like their eviction was based on some of the damage that has been that has resulted in the unit, but that is due to DV. And then are unit repairs due to DV incidents covered?
Sure. So for the first question, it's kind of nuanced, but I would say yes, you should still have that VAWA protection for the eviction if the underlying eviction is because of damage because of the domestic violence. So yes, I think that protection would still be there, because if you take away the domestic violence incident, if there wouldn't have been any damage, then that survivor didn't do anything wrong. So yes to the first question. To the second question, I think if it's not as cut and dry. I think if the survivor has kind of documented that domestic violence incident and can show that the damage is stemming from this abuser, the landlord does have a duty to help the survivor in that situation, but it might be, potentially moving them to a different unit or maybe bifurcating the lease, which we'll talk about in a later slide. I don't know if the law specifically says the landlord has to cover the damages, but I don't think they should be able to evict the tenant because of those damages.
A few more questions.
Firm answer there, but
thank you. A few more questions have come in. What if the abuser is also on the lease? Can they be asked to leave and not the victim? And then similarly, someone's asking, what if the abuser is the only person on the lease and the survivor is still in need of, and the survivor still needs the housing?
Sure. So let me go to the next slide because that is talking about removing the abuser. Oh, going the wrong way. Sorry. So to answer the first question, you can bifurcate a lease, which is what we say on this slide, which is separating the lease between the survivor and the domestic violence abuser. And so in this situation, public housing authority or landlord can split the lease and separate the two parties and allow the victim to stay in the unit. The survivor of the DV who wants to remain in the unit has to request their landlords to do this. So it's not something that automatically happens. The survivor needs to make a request specifically to the landlord asking them to split the lease. When this happens, a tenant generally has about 90 days or until the lease expires to then establish that they're eligible to remain in the lease, meaning that they have enough money to cover the rent on their own, or if there's other eligibility requirements for the unit, they have to show that they could qualify on their own. So this is difficult because a lot of times a party maybe only can qualify for a lease or be eligible for a lease because they have two incomes or whatever the qualifications might be. So in general, this seems like a good protection to be able to split the lease, but oftentimes we see survivors not actually able to qualify for the lease on their own. So in that case, they would need to transfer to a different unit or potentially a different housing provider. And under VAWA, the landlord has some duties to help that survivor transfer into a different program if needed. So they do have to help that survivor find alternative housing if needed.
There were a few more. There's a building that's running into a problem of other tenants letting people in who have restraining orders against them. So they're asking if it's true that there's nothing anyone can do if the person who has a restraining order against them is invited into the building.
So if a person has a restraining order, the rights of that restraining order are still intact. If someone else is letting the abuser in, that survivor can still call the police or call the landlord and say, I have a restraining order, this abuser is coming in. They're not legally allowed to be within whatever distance the restraining order says. And so the landlord has a duty to provide a safe environment for their tenants. So if a landlord is on notice that this tenant has a restraining order and that this abuser can't come on the property, they have a duty to not let that abuser onto the property. Obviously, things happen if guests are letting them in. A landlord can't be everywhere at once, but once they're put on notice, that's not something that should be on the survivor. So it's not something that should mean she is breaking her restraining order or could lead to an eviction just because other guests outside of her control are letting in this abuser. So in reality, it's not so cut and dry because obviously if a guest is letting in an abuser, there's not so much a landlord can do about that, but they do have that overarching duty to provide a safe environment for the survivor. I think there was also a question about what do you do if the survivor is not on the lease? Unfortunately, this VAWA protection is for people who are on the lease, so household members. So the protections under VAWA wouldn't apply to someone who's just a guest in a unit.
I think there are two more VAWA related questions. What if the survivor is afraid to contact the police to file a restraining order? Is documentation required to be approved? So
let me go to the different documentation options. So survivors have a few different options that they can go to. It doesn't have to be a police report. So there's something called a self-certification form. There's a HUD form. It's form 5382. You can Google it and pull up that form. It's also something a landlord should be providing to tenants, but that's something that the survivor can fill out on their own and then provide to the landlord, which is enough documentation to use this VAWA protection. So it does not need to be a police report. It can be, a tenant can also do a police report, a court order, a restraining order, some kind of administrative record showing that they are survivors of this domestic violence. They also can get a statement from a third party, someone else who maybe is aware of the abuse and willing to make a statement about why this protection is needed. And then the survivor, if the housing provider isn't happy with whatever documentation they're giving, the survivor also can give additional statements or evidence to the housing provider. So it does not need to just be a police report. Going off of what we just mentioned about these self-certification forms, a landlord has a duty to make a tenant or an applicant aware of their rights under VAWA. So many people don't realize that they have these protections and that they're entitled to them under the law. So it's really critical to understand the importance of these notice requirements. A housing provider has to provide a HUD notice and self-certification form to all applicants and tenants. At the time, either the application is denied or assistance is denied, or a tenant, maybe while they're doing their annual recertification or re-signing a lease, a landlord has to provide them their notice, their rights under VAWA. This notice has to be given to all adults in the household. So not just the head of household, not just the person who's doing the annual recertification. It needs to be given to every adult in the household. Let's see. Yes, and then these forms are available in many different languages. So the landlord has to provide these notices and then keep providing the notices to the tenants throughout the lease. Another right that a survivor has under VAWA is the right to an emergency transfer. So this is that the survivor can transfer to a safe environment. So these are really crucial for survivors to find safe and affordable housing. I think one of the questions someone asked is, what do you do if both parties are on the lease? We talked about splitting the lease. That might not always be the best option. It might be that the survivor needs to transfer to a different unit. And so housing providers that are covered under VAWA, they have to develop emergency transfer plans to coordinate these emergency transfers. So the burden is on that housing provider or on that landlord to have a process in place to transfer these survivors to another unit or to another property. A survivor is eligible for these emergency transfers if they expressly request a transfer. So they have to do that. It's not just something that the landlord will come to you for. They have to expressly ask for it. And when they reasonably believe that they're threatened with imminent harm or further violence if they remain in their current unit. Or if the survivor has been sexually assaulted on the premises within the last 90 days of the request. So there are some conditions, but if either of these things have happened, that survivor has a right to an emergency transfer. A housing provider can process this request if it's not in writing. Again, as long as that tenant is expressly requesting it. But like always, best practices is to put something in writing, but understandably, survivors might be hesitant to put this abuse in writing or to put this request in writing. So it does not need to be in writing to be valid. It can be an oral request. Emergency transfers don't supersede other eligibility requirements. So this doesn't mean a survivor can now be transferred to a unit that they otherwise wouldn't qualify for. But it does still need to be a process that the housing provider has put in place to help find a unit and help transfer that survivor if they qualify for a new unit. So it's not on the survivor to go out apartment hunting. Yes, I think, was there a question, Nicole?
Yes, there are a few questions. Someone is asking, what if the intimate partner violence happens after moving in? Should they still complete the self-certification form? Yes.
So the incident doesn't have to happen prior to moving in. So oftentimes it is happening while they're, honestly, both parties are usually on the lease. So if it's something that the tenant or the survivor is wanting assistance for, yes, they can still do the self-certification form or any of the other documentation methods.
Can cities incorporate Vawa protections into tenant protections? So they're thinking of San Jose's tenant protection ordinance or the just cause eviction.
Yeah, so in a later slide, we'll talk about the California specific rules that kind of almost line up with Vawa protections. But these protections that we're talking about right now are just federal protections for federally subsidized housing. So if each county or city or state wants to kind of create their own protections, they can, but it's not automatically incorporated. So like a private housing wouldn't have to follow these VAWA regulations.
Got it, thank you. And then the last, there's two other questions. Has Bay Area Legal Aid successfully defended a domestic violence survivor who does not live in a federally subsidized unit to give them these protections? Is there a way to use a different protected class, maybe sex, as a protection?
So if this question is kind of in regards to defending evictions, then yes, these are still protections that you can raise even in private housing. If you mean defending like a restraining order, I'm in the housing unit, so I'm not sure. I know our family law unit does restraining orders and does successfully get restraining orders granted and abusers kicked out of units because of those restraining orders. But any discrimination based on any other protected class is something that you can raise regardless of if you're in a federally subsidized unit. So a landlord can't discriminate based on any of those other protected classes.
Thank you. And then the final question is, if they live in an ADU without a contract, are they still covered under these rights?
So these VAWA protections are just, again, for those federally subsidized housing. So if it's not a housing provider that is federally subsidized, like Section 8, the project-based, then I don't believe this would cover them. But as we'll cover again in another slide, California law does have some similar protections for other tenants outside of the federally subsidized housing realm. I'm not sure if it would protect from an unpermitted unit or an ADU. It kind of depends on case by case, what kind of housing you're in and what laws apply. Sorry, that's not a great answer. Okay, so I'll continue on. So some confidentiality, this was a question someone brought up of obviously a survivor might not want to come forward with evidence of the abuse or documenting the abuse. And so under Vawa, confidentiality is really important. And so it's put on the housing provider to make sure that this information is really protected and kept very confidential. And so when a survivor is submitting a Vawa self-certification or other kind of documentation, the housing provider has to maintain it in strict confidence. So a housing provider can't allow anyone administering assistance or other employees to have access to that information unless it's explicitly authorized. And so they have to, it can't be entered into like a shared database or disclosed to other people, other housing providers, unless it's requested or time sensitive because of maybe like an emergency transfer or something that the survivor has requested that information be shared. And so the burden is on the landlord to keep this information very private.
All right, so thank you, Sarah, for this wonderful explanation on Vawa. And let's run the hypo. Can you pull up the poll, please? All right, great. So the tenant is a survivor of domestic violence and wants to assert Vawa protection and request an emergency transfer. The tenant cannot request an emergency transfer because Vawa only applies to women. True or false?
In another minute, we've got about 50 of you answering so far. Okay, I'll share the results. Not all of you yet, but we've got quite a consensus here.
Yeah, I mean, the name can be misleading, but it applies regardless of gender. So
yes, it does not just apply to women.
Mm-hmm.
Okay.
All right. So let's end the poll. And
there are a couple more questions, and if these are going to be answered in this deck, this piece of the deck, that's also okay. But just want to flag a question about in the incident that a tenant is alleging they were sexually assaulted by another tenant, how that would proceed, and then.
So I'm not sure what the question means. So what would the survivor be requesting in that
scenario? Catherine, do you want to come off of mute and or just specify in another message?
In the meantime, we'll continue on, but definitely when we finish a slide, we can come back to that question. All right, go ahead, Kevin.
All right, thank you. So California laws protecting domestic violence survivors. Next slide, please. So California has several laws that help domestic violence survivors maintain safety in housing. And there are 4 rights approximately, and right to have locks changed, right to break the lease, right to protection from eviction, and housing providers' duty to provide safe housing. Now let's first talk about the right to have the locks changed. Next slide, please. A survivor of domestic violence can mandate that their landlord or property manager change the locks if the abuser is a tenant, or even if the abuser is not a tenant. What the survivor must do is a bit different depending on whether the abuser is a tenant of the premises or not. If the abuser is a tenant, a survivor must provide a copy of a court order that excludes the abuser from the home and make a request in writing to have the landlord or property manager change the locks. The court order can be a temporary restraining order or protective order, and the court order must have been made within the previous 180 days of the request. For example, if the court order is a year old, a landlord does not have to change the locks, unfortunately. And if the abuser is not a tenant, a survivor can provide a copy of a court order or police report. Again, the request to change the locks must be in writing. If a survivor provides their landlord or property manager with the correct documentation and provides a written request to have the locks changed, the landlord or property manager must change the locks within 24 hours. And if the landlord does not change the locks, the survivor can go ahead and change the locks themselves. If they change the locks themselves, they do have to use a similar or a better quality lock and must notify landlord within 24 hours after changing the locks and provide the landlord with a key. Next slide, please. The right to break the lease. Another important right that California law provides is the right to break the lease agreement. Every survivor has the right to terminate the lease agreement as it applies to them so that they can remove themselves from the abusive situation. A survivor does not have to remain in a lease agreement and therefore an abusive household simply because they signed a long-term lease. To break a lease agreement, a survivor must notify their landlord or property manager in writing and attach documentation of the abuse that is less than 180 days old. The documentation could be a police report, a restraining order, protective order, or documentation from a qualified third party like domestic violence caseworkers at a nonprofit organization. If a survivor provides proper documentation and makes the written request, the survivor is only responsible for 14 days of rent following the notice. The survivor can vacate the unit and will only be responsible for the prorated 14-day period of the notice. But if the landlord re-rents the unit within the 14-day period, then the survivor's rent is prorated and will not be responsible for the rent when an alternative tenant resided in the unit. Next slide. Yeah.
So another right that California law provides domestic violence survivors is, like we talked about earlier, this protection from eviction. So unfortunately, this law does not apply if the abuser is a tenant in the same units. So a landlord cannot evict a tenant based on an act of domestic violence, sexual assault, human trafficking, stalking, or abuse of an elder or dependent adult. Similar to the right to break a lease, a tenant has to have documentation by a qualified third party or a restraining order or a police report issued within the last 180 days. And it's really important for a tenant to assert this defense. If they get served with an eviction, this is also known as an unlawful detainer. You'll hear this term a lot in part 3 of our training. But once a tenant is served with an eviction, once they're served with that court paperwork, a tenant has 5 days to file an answer. And so if a survivor is being evicted based on an act of domestic violence, the survivor has to assert that affirmative defense in their answer. And so if they don't assert that defense within their answer, they might lose the ability to bring that defense later. And so if some of you have clients who have gone through this process, or you've seen the answer forms when there's an eviction, you might kind of recognize what we're talking about. There is a specific box that the tenant can check for this affirmative defense that talks about if they've had a restraining order in the last 180 days or police have been called in the last 180 days. Again, like everything, there's an exception to this. A landlord can still evict a survivor if both of these conditions are met. So 1, if the tenant allows the abuser to visit the property. or the landlord reasonably believes that the abuser poses a threat to other tenants. And 2, that the landlord had previously given the tenant a 3-day notice to correct the violation, meaning a 3-day notice to not let the abuser back onto the property. And then if the survivor still lets the abuser back onto the property. So in those scenarios, a landlord could still move forward with an eviction. The caveat to this is if the survivor seeks a restraining order after that 3-day notice, and then is trying to enforce the restraining order by contacting law enforcement, or if the abuser is trying to break that restraining order, the survivor could still bring these protections to an eviction, even if there had been a 3-day notice that they did not comply with. Another right that a tenant has in California is the right, the protection if they are calling emergency assistance, they have a right to a protection from an eviction. So a landlord can't prohibit, limit, or threaten the right of a person to contact emergency assistance if they believe that emergency assistance is necessary. No documentation is required for this affirmative defense, but any written documentation that a tenant might have, like a police report, a restraining order, a qualified third party, that would all be helpful in actually bringing this defense and winning at trial. So again, an affirmative defense is a defense that's recognized by law that may allow a tenant to win their eviction case and stay in their home. So any evidence that your tenant might have that can provide, that can show that they were contacting emergency assistance because it was necessary would be very helpful for us in the legal aid world when we're defending these evictions, or for a tenant that you might have going through this process on their own. Any additional evidence that they can provide would help their chance of winning an eviction case. And so lastly, housing provider owes a duty to its tenants to provide safe housing. We touched on this a little bit before. And so this is a general duty that a landlord has to maintain the property in a safe condition. So tenants may request simple improvements like better lighting, or changing or providing better locks to exterior doors. And these are all, reasonable requests that a landlord should comply with because of that duty to provide safe housing. If a landlord breaches this duty, they may be subject to civil liability, or potentially something that a tenant could bring up as a defense to an eviction. Another hypo. I think this is our last typo. So does Tammy tenant have a right to be protected from eviction for a stalker situation? Give it a few more seconds. Okay. The answer was true. Yes, Tammy does have a right to be protected from eviction if this is the situation of a stalker. So like we talked about prior, it's not just domestic violence incidents, it's also that sexual assault, human trafficking, stalking, all of these things can be covered under the eviction protections.
All right, let's talk about 1482, just cause and rent cap. We only have 15 minutes, so maybe need to rush a little. Sorry about that, folks. And so AB 1482 is a CA statewide law that went into effect on January 1st, 2020. It requires a landlord to have a just cause in order to terminate a tenancy. This law only applies to certain covered properties. For those covered properties, a landlord may not terminate the tenancy without just cause if a tenant has lived at the unit for at least 12 months. Also, covered properties cannot increase rent more than 5% plus the percentage change in cost of living, or 10%, whichever is lower. A tenant may not waive their rights to these protections, and any agreement to do so by the tenant is void as contrary to public policy. If a unit is already covered by any local evictions and or rent increase regulations, the unit remains subject to those local regulations, and the statewide law does not remove or replace those tenant protections. The eviction provisions only apply. So, all right.
Sorry.
The eviction provisions only apply after all tenants have lived in the unit for 12 months or more, or where at least one tenant has occupied the unit for 24 months. A tenancy may not be terminated unless the landlord has one of the allowable just cause reasons, which must be stated in the termination notice. Just cause simply means that the landlord must have one of the stated reasons under AB 1482 in order to terminate the tenancy. And just cause reasons are categorized as either at fault or no fault. All right, so let's look at these at fault just causes. At fault means that the tenant is at fault due to any or one or more of the following reasons. The most classic one is the non-payment of rent, or lease violations, nuisance, waste, refusal to enter into similar lease agreement, criminal activity, assigning or subletting without the landlord's consent, refusal to allow owner enter the premises, using premises for unlawful purposes, employee, agent, or licensee's failure to vacate after termination, and failure to vacate after tenant provides notice. And let's talk about the no fault just causes. No fault means the tenant is not at fault, but the landlord is still choosing to evict tenant due to any one or more of the following reasons. The owner decides to move in for himself or herself, withdrawal of the residential real property from the rental market, owner complying with an order to vacate, for example, regarding habitability, intent to demolish or substantially remodel. Generally, tenants are entitled to relocation assistance under no fault evictions. The mere expiration of lease or rental agreement is not a just cause to terminate the tenancy. Now let's talk about the security deposits. This is the last slide. So the landlord has 21 days from the day the tenant moves out to refund the security deposit. And they may deduct for damages beyond normal wear and tear, cleaning fees, and unpaid rent from the security deposit. They should provide an itemized statement of deductions and receipts if they withheld some or all of the security deposit. If a tenant disagrees with the amount withheld, consider writing a demand letter and filing a small claims court eviction. The security deposit cannot be more than 3 times the monthly rent for furnished units, or 2 times the monthly rent for unfurnished units. So no statutory obligation for a landlord to pay interest to tenant on security deposit, and proper use of security deposit by landlord is limited to Civil Code section 1955. So like application to rent defaults, repair of damages to premises, exclusive of ordinary wear and tear, caused by tenants or tenants' guests, cleaning of the premises beyond ordinary wear and tear upon tenants move out, and if a lease allows, landlord may apply the deposit to other unpaid monetary obligations, late fees, attorney's fees, litigation costs. I guess that's it. Thank you for listening.
So we hopefully have some time. I know this one, I think, a little bit longer because we were answering questions throughout. So if there's any questions we don't get to, again, we can follow up next week or through email. So again, here's just our legal advice line number. If you do have clients that are hoping to reach out to us, I would advise to call as early as possible. They take calls on a rolling basis, and just if they're understaffed or for whatever reason there's a lot of calls, they will sometimes close the line early. So if you have a tenant who needs kind of immediate legal assistance, calling towards the earlier half of the morning would be best. And then I'll end my slideshow and then we can answer any questions.
I am seeing AB 1482 does not apply to tax credit properties, correct?
So is this talking about the just cause protections?
Colleen, could you specify in the chat? Oh, for rent increase.
Yeah, so it's a little bit difficult because if you're in San Jose, we also have our own rent restrictions and just cause. So it's kind of hard to give just a yes or no. It depends on how the property is being held. If there's, you know, maybe it's a Section 8 housing. So potentially it might apply depending on what type of housing that you're in. So it's best if you're unsure to see what your lease says. Sometimes a lease will say whether or not they're exempt from the Tenant Protection Act, or if you're in San Jose, the Tenant Protection Ordinance. And then also if you have a tenant who's been served with an eviction, it's also on the landlord to say whether or not their unit is under the Tenant Protection Act.
Thank you. What if a survivor is being notified? Oh, what if the apartments have to do treatments for bugs and a client has to remove their furniture and stay in a shelter for 2 months, and they're trying to charge the client for the treatment?
So for the second half of the question, if they're trying to charge the client, one, it depends on what the lease says. And so for the most part, usually leases will say if it was a problem caused by the tenant, then it's the tenant's responsibility to pay. If it's a problem caused by the property, let's say it's like bed bugs, sometimes this is just an issue building wide. And if it can be shown that it's, you know, something that wasn't brought in by the tenant, then it's the landlord's responsibility to pay. For this specific question, 2 months seems like a really long time to be relocated. So I'm not sure if there's more going on than just pest control. But it does seem like an unreasonable amount of time to be forced out of the units. Usually this is, you know, a couple treatments from pest control, maybe a tenant's out for a couple days. But 2 months seems like, without more information, like a really long time to be relocated.
Thank you. What happens if a landlord sent a handyman to fix a plumbing issue, which then caused a flood to the entire house, causing the tenant to move to a hotel?
Oh, goodness. So obviously any damage caused by that would not be the tenant's responsibility. It's hard to say exactly what the landlord would be responsible for with relocation. I would say if it's something that was caused by the landlord's handyman, they should compensate the tenant for if they're staying in a hotel. But again, in practicality, if we have a landlord refusing to pay for those hotel costs, and then a tenant taking that amount out of their rent, it could still lead to an eviction. So in these situations, we'd say communicate with your landlord, put in writing, this is how much money I paid, I would like to be compensated, or, you know, I want this deducted from my rent. But you want to try and make that an agreement between both parties, because if a tenant is just on their own, again, deducting rent or paying for something that a landlord hasn't agreed to, they could open themselves up to an eviction being filed. A landlord can file an eviction even if it's something that a tenant has affirmative defenses to. And so even filing an eviction is something that can show up on a tenant's background report, credit check. You know, it can harm their ability to find housing in the future. So you really want to, if you can avoid it, work with the landlord to stop that eviction from even being filed.
Okay. I recognize there's 4 minutes left. I see 2 questions. One, do you provide resources and advice for clients who do not live in California?
Bay Area Legal Aid, we are restricted to just people living in the 7 Bay Area counties. But if someone calls living out of state, usually our legal advice line attorneys are happy to, if they are talking to a tenant in a different state, maybe try and do a Google search of legal aid that might be in their area, but that's not someone who would qualify for our services if they're out of state.
Thank you. And then there was a request to return to a previous question about tenants letting a person in who has a restraining order. So the landlord said that they have legal advice that if a tenant invites someone into the building and they block that guest from entering, this violates the tenant's constitutional right to free assembly. Therefore, the security guard is not permitted to identify and block guests who have restraining orders or who have been trespassed.
So if it's the tenant if it's a survivor who has a restraining order, a landlord can't let that restraining order be broken, if that makes sense. But a restraining order is usually limited to that person and kind of a sphere around the person. So maybe it's staying, 3 yards away or some distance away from that survivor. A landlord couldn't force the survivor to let that person into their unit. If the question is in general, if it's maybe an apartment complex or there's common areas, other tenants can associate with that. I'm going to call them the abuser, but the person who has the restraining order against them. But that landlord can't force the survivor to interact with the abuser and break their restraining order. So yes, they might be present on the property, but they couldn't, force them to come into their unit, or if there was other people in the unit trying to invite them in, they do have to honor the survivor's restraining order. If the question was kind of in general about letting the abuser onto the property, maybe because another tenant was inviting them in, then yes, but it can't be breaking the survivor's restraining order.
Thank you. Can you ever challenge? Oh, sorry.
Sorry, just the clarification for, I think I misspoke. So to clarify, an eviction filing will show up on your credit report. So no, sorry, it will show up on your credit report if there's been a judgment against you. But if it's been filed against you, sometimes applications will ask if has an eviction ever been filed against you. So it might affect a tenant's ability to just find other housing if they're putting in an application that they've had an eviction filed against them, even if it was an unjust eviction, or even if maybe they won. Sure, let me put up the last slide. But yes, it's not going to harm your credit until there's been a judgment. And if you're in Santa Clara, at least, we do have strong laws sealing evictions, even if there has been judgments. But if you're in other counties or other cities, it's definitely still something to avoid.
And the last question I'm seeing is, can you ever challenge a lease's claim that AB 1482 doesn't apply to a unit?
Yes, you can always challenge that. We have to do that a lot because landlords will just say it doesn't qualify, and we still want to bring that up as a defense. And so it's again not kind of as easy as yes it applies or no it doesn't oftentimes. And so we usually try, and if we're filing an answer, say yes it applies, and then as we go through the discovery process or we get more information, we figure out if it actually does apply or not. But yes, we don't just have to take the landlord's word for it. We can say it applies if we think it does, even if a landlord does not agree. And then, sorry, I'm trying to share my screen again.
As Sarah is sharing her screen, just thank you once again, Sarah and Kevin, for sharing all of that information with us. And I'm going to kindly point you to the chat where I've dropped a feedback form. We'd really appreciate if you just take a couple minutes to fill it out. It really helps us tailor our trainings to ensure that we're putting together trainings and content that you'd like to see. So I'd really appreciate if you fill out that feedback form, and we hope to see you for part 2. Which is on the 26th.
Oh, I'm just failing here with the final slide. Hold on.
If Sarah's not able to get to the last slide, I do just want to remind folks, everyone's receiving the slide deck. So you're going to have that contact information easily available to you. And Kevin also dropped in the chat the legal advice line. So you have all of this information in multiple forms, but thank you all.
Hopefully it's up on the screen now. I know we're past time, but
It is up on the screen. I will be closing the meeting in a moment, but thank you all so much once again, and hope to see you for part 2 and part 3 soon. And thank you, Sarah and Kevin, so much.
Thank you guys for attending today.
Bye, everyone.